Good morning, everyone. My name is Eric Athey, and I'm joined here with my partner, Micah, Saul. We are both with McNees, Wallace, and Nurick in their Lancaster office. And McNees is a law firm. We have about 150 attorneys throughout Pennsylvania, Ohio, Maryland, and I think that's it. We're pleased to join Trout today at their annual payroll seminar. And today we're going to be talking about sort of a broad discussion of recent developments in employment law. There's a lot to talk about today. I suspect we may be rushing towards the end, so just a forewarning, but we deliberately left some of the less interesting items for the end. So if you feel like you've missed anything, we can always feel free to give us a call afterwards, but I think we'll get through it. Wanted to just start it off with, since this is a payroll seminar, we're going to, what's going on there? Next slide. There we go. Wanted to start off with a wage and hour update. And it's not very often that we have much to report regarding Pennsylvania's wage and hour law, but there's some very important developments here that we want to touch on today. Just by way of context, when we talk about wage and hour law, there are really two primary laws of concern. There's the federal law known as the Fair Labor Standards Act, and then the state law, which is the Pennsylvania Minimum Wage Act. Historically, the Pennsylvania State Minimum Wage Act has been viewed as sort of just parroting what the federal law said. There really weren't that many differences between the two, and courts sort of interpreted them the same way. However, over the past 15 years, folks in Harrisburg and the courts have found some quirks in the wording of the state law, and have also issued some regulations that have sort of created a separate set of concerns under state law that you don't necessarily need to worry about under federal law. And the two items that we're going to be talking about today are such items. These are issues that are of primary concern under state law. The first one, not going to spend a whole lot of time on this particular slide because it pertains to tipped workers. And some employers are permitted to pay their employees less than the federal or state minimum wage as long as the difference is made up with tips. And obviously this primarily applies to restaurants, but not strictly restaurants. In any event, effective August 5 of this year, the state law regulations were updated and sort of made a little more stringent for employers that use tip credits in order to meet minimum wage requirements. One of the interesting aspects of the new regulations is that it really cements the fact that any tips paid via credit card belong to the tipped employee and not to the business. I personally always wondered, whenever I'm adding a tip to a credit card receipt, does it actually make it back to the server? And this new tightening of the state regulations certainly makes sure that that's the case. This next slide, and actually the next two slides, are where I think most of you may have some concern, and so it's a bit of a confusing issue, but try to stay with me here. The primary issue involves salaried non-exempt employees, and in this day and age we don't see many clients with salaried non-exempt employees. However, it's going to take a turn towards the end of my discussion of this topic, so just stay with me. Some employers do use salaried non-exempt employees, and these are non-exempt employees, meaning they're entitled to overtime, but the employer, instead of paying them on an hourly basis, chooses to pay them a fixed salary to cover their hours worked, and then they pay them some sort of overtime premium if they happen to work over 40 in a week. You'll see on this slide there are two different columns. On the left, there's the federal rule, which says, if you have a salaried non-exempt employee, you have to pay them an overtime premium when they work over 40. And that overtime premium is 1/2 of their regular rate of pay. We'll talk about regular rate in a second, but the key there is 1/2. The theory under the federal law is that the salary covers their straight time. It covers the time of the time and a half component of overtime. So under the federal rule, when you're calculating regular rate of pay, you take the non-exempt employee's total weekly compensation which may include a bonus or a commission or something along those lines, and you divide it by the total number of hours worked. So if someone happened to make $100 total comp in a week and they worked 50 hours, their regular rate of pay, 500 divided by 50, is $10 an hour. The state law has been interpreted by courts and this year in a new regulation as a little requiring a slightly different formula. Under the state, and again, here I'm in the right-hand column of the slide, these new regulations that took effect on August 5 says that overtime hours for someone being paid a salary non-exempt employee has to be paid at time and a half of the regular rate. So the calculation is different. Now what we're saying is the regular rate calculation is total weekly comp divided by 40 hours, not divided by the total number of hours worked that would apply under the federal rule. So how does this translate in terms of an actual example? Next slide. Again, the federal rule example, we'll use easy numbers here. If we have a salaried non-exempt employee working a 50-hour week, being paid a fixed salary of $500, but let's say they also make a bonus or a commission or maybe some sort of piece rate supplement of $50 on top of that salary. So now we've got total earnings being 500 plus 50, and under the federal formula, you divide that by total of hours worked, which is 50, which gives you a regular rate of $11 an hour. So when you're calculating the overtime premium, what we're doing is we're taking the 10 overtime hours, that's hours from 40 to 50, we're multiplying that times 1/2, because again, the salary covers the time. We're just interested in calculating the halftime premium. And then you multiply that times 11, which is the regular rate that we just calculated. So that overtime premium is $55 for that week. And the total pay is the $550 plus 55, or $605. It is a more complicated equation in order to comply with the state law now. Using the state law example that I have here, same employee, 50-hour week, paid a $500 salary for those 50, for 50 hours. Plus they also get a bonus or a commission or a piece rate supplement of $50. So there we've got a regular rate of 500 plus 50. But now under the new regulations, we divide that by 40 hours, not by the 50 hours worked, but by 40 hours. That's the new state law requirement. And that yields a regular rate of $13.75 an hour, not $11 an hour. And more importantly, when you look at the overtime pay equivalent, it's the 10 hours of overtime times 1.5, not times the half, which would be the federal equation, but times 1.5 times the new regular rate that we have, $13.75, yielding an overtime premium of $206.25, or a total pay of $756.25. So you see, there's quite an increase there in terms of the total overtime due an employee in this situation. Now, many of you may be thinking, well, we don't have any salary non-exempt employees, so we don't have to worry about that. The note that I included on the lower right-hand part of this slide, please circle, because there is a concern that this calculation doesn't just apply to salary non-exempt employees. In the preamble to the regulations, the Department of Labor and Industry commented that the same methodology would apply to non-exempt hourly employees who receive something like a bonus or a commission or a piece rate supplement to their earnings. So again, now that's just the preamble to regulations. It's not really clear in the regulations themselves, and that's how they intend to enforce it. But the fact that it's in the preamble suggests that someone at Labor and Industry likely intends to enforce the law in that manner against or for hourly non-exempt employees, not just salary non-exempt employees. And for those of you that pay bonuses, attendance bonuses, or production bonuses or commissions to non-exempt employees, it could be a significant compliance issue, which you'll want to get out in front of, because again, these regulations took effect on August 5. Definitely something to call your accountant or attorney about. Next slide, please. So Does this equation apply to all supplemental payments that are paid to hourly or salaried non-exempt employees? The answer is no. There are a number of exceptions that don't have to be factored into the regular rate equation. And in fact, the same basic exceptions apply under federal and state law. You'll see that certain gifts, like a Christmas gift of a nominal value, likewise, vacation pay, holiday pay, sick pay don't have to be factored in. The big one here is discretionary bonuses. Discretionary bonuses, meaning bonuses that are left to the discretion of the employer. The employer decides whether it's going to be paid, decides when it's going to be paid, decides how much it's going to be paid. They can be excluded from this equation. But typically, if we're talking about an attendance bonus or if we're talking about a production bonus, that's not discretionary. That's typically, explained as something that's guaranteed to the employee, and that non-discretionary bonuses would affect regular rate. Likewise, profit sharing contributions, health insurance contributions are excluded. Daily overtime premiums, the premium pay if someone works over 8 hours in a day can be excluded. Likewise, shift and weekend premiums can be excluded if they are at least time and a half of the employee's hours wage. Next slide. I'm going to turn over to Micah for a discussion of the Amazon case.
Yeah, thanks, Eric. So in addition to significant regulatory development that Eric just walked us through, over the past year, we saw a major shift or a major development, at least, from the state courts here in Pennsylvania with respect to wage and hour issues. And the case that development or those developments came to us through is known as In Re Amazon.com, Inc. So a little bit of background for you here about what was happening at Amazon and how this dispute arose. At Amazon, employees were required to report to work prior to the start of their shift to undergo a security screening. And then after the end of their shift, they're required to undergo an exit security screening as well. And Amazon took the position that these screenings occurred pre and post shift. They're off the clock. They're not compensable. So Amazon employees, as you might imagine, took issue with that interpretation and initially attacked the idea that these were not compensable periods of time under federal law. So they filed a lawsuit, class action lawsuit under the Fair Labor Standards Act, and they argued, pre and post shift security screenings were compensable time and they should be paid for them. That case made it all the way to the United States Supreme Court in 2014, and the United States Supreme Court said, no, Amazon didn't violate the Fair Labor Standards Act by not paying you for these pre and post shift security screenings. The United States Supreme Court held that the Portal to Portal Act of 1947, which amended the Fair Labor Standards Act, meant that waiting for security screenings were not, quote unquote, hours worked under the Fair Labor Standards Act. In addition, the Supreme Court also commented that even if these were hours worked, there's a de minimis, what's known as the de minimis exception under the Fair Labor Standards Act, in which insubstantial or insignificant time spent pre and post shift is not compensable, again, under federal law. So Amazon employees went to federal court and lost. But that's not where the story ends, obviously, because we're bringing you this update. So in state court, Amazon employees essentially advanced the same arguments. They said, the pre and post shift security screenings are in fact compensable, not under federal law this time, but under the Pennsylvania Minimum Wage Act. And as you might imagine, that litigation wove its way through all the way to the Pennsylvania Supreme Court. And there was a different outcome this time for Amazon employees. So Amazon in litigation before the state courts advanced the same arguments. They said, listen, the Pennsylvania Minimum Wage Act is interpreted essentially in a way that, as Eric put it earlier, parrots the Fair Labor Standards Act. And so these pre and post shift activities don't fall within the ambit of hours worked. And even if they do, there's this de minimis exception. And the Pennsylvania Supreme Court rejected both of those arguments. The Pennsylvania Supreme Court instead held that the Federal Fair Labor Standards Act establishes a floor below which wage protections cannot fall, but that state legislatures are entitled to confer greater protections to employees through state legislation, and that's exactly what the Pennsylvania legislature did through the Minimum Wage Act. So the pre and post shift screenings fell squarely within the definition of hours worked under the Pennsylvania Minimum Wage Act. And even if the court was to determine that hours worked were not covered by the pre and post shift security screenings, there is no de minimis exemption or exception to hours worked under Pennsylvania state law. So if we could move to the next slide, please. The Pennsylvania Supreme Court commented then that there are essentially 4 categories of time that are compensable hours under the state Minimum Wage Act. And those categories include time during which the employer requires an employee to be on the employer's premises. So, for example, pre and post shift security screenings. If you're scheduled to work at 8 o'clock and you have to be at work at 7:50 to go through the security screenings, your compensation starts at 7:50. Time during which the employer requires an employee to be on duty or at a designated job site. If again, you're on duty, you're performing your work, that's obviously going to be compensable time. Likewise, the Supreme Court used this case as an opportunity to clarify that time spent traveling as part of an employee's duties during normal working hours is also unquestionably compensable. And then finally, time spent when an employee is either employed or permitted to work. And we'll get into this a little bit later on when we talk about remote work considerations. But if you're allowing an employee to perform work, even if it's outside their normal scheduled hours, the Supreme Court has clarified unequivocally that that time is compensable under the Pennsylvania Minimum Wage Act. So if we could go to the next slide, and we're going to talk about a couple of the key takeaways then from the Amazon case. So first of all, most importantly, compliance with the Fair Labor Standards Act does not equal compliance with the Pennsylvania Minimum Wage Act. So Amazon was in full compliance, right, with the Fair Labor Standards Act, according to the United States Supreme Court. They were not in compliance with the Pennsylvania Minimum Wage Act, according to the Pennsylvania State Court. So all employers should understand that if we're confident in our position under the Fair Labor Standards Act, we also need to be confident in our position under state law as well. And that would require, our second key takeaway here, which is review your payroll practices and make sure that we're capturing all hours worked. It's not just the pre and post shift activities, but also the risks associated with remote work. Are employees performing tasks who are working remotely? Are they performing work-related tasks that they're not capturing, they're not documenting while they're submitting their timesheets or while they're filling out their clocking in and clocking out? And if that's the case, that time that they spend working under the Amazon decision, that's going to be compensable time. So we need to make sure that we're capturing that time. We need to make sure that we have policies and practices in place that captures all time worked, both pre and post shift, outside of normal working hours. And then finally, there is a question now about whether rounding practices are viable under Pennsylvania state law. The Amazon case, again, suggests that they may not be. So it's worth, if you use rounding practices, it's worth taking a second look at them, reviewing those rounding practices with counsel, and making sure that you're confident in your position now under the Pennsylvania Minimum Wage Act in light of the Amazon decision. And the last takeaway is that, when we talk about these cases and when we talk about these principles, they're not applying in most cases to just 1 or 2 employees. They're going to be applying to all of your non-exempt employees who are subject to the same policies and procedures. So there's a real risk that a class action could be brought against you if you're not in compliance with Pennsylvania Minimum Wage Act. And that means increased liability. That means increased exposure and increased cost to an employer where that compliance is not documented.
That's a great point, Micah. I mean, the real takeaway here is that for years, for decades, if you complied with the federal wage and hour law, the Fair Labor Standards Act, you pretty much were also complying with the state law. That's not the case anymore. And increasingly every year, the state law is getting a little more onerous for employers. So if you do your own sort of wage and hour research in terms of the legality of practices, make sure you're checking both laws. If you're checking with your accountant or with your attorney on wage and hour issues, make sure that they're taking a look at both state and federal law. This next slide talks about some trends. These are not laws that apply to us as we sit here in Lancaster, Pennsylvania, or really anywhere in central Pennsylvania, but they're laws and ordinances going, that have been enacted elsewhere in the state or across the nation that we just thought might be interesting because they're indicative of trends that we're seeing across a number of states and jurisdictions throughout the country. First one just points out that 16 states now require paid family or sick leave benefits for some private sector employers. This year, Delaware and Maryland were added to that list. They passed laws that took effect, and they joined New Jersey and New York. So now most of the states that are contiguous to Pennsylvania do require some form of paid family or sick leave. Pennsylvania hasn't passed such legislation yet. It is a requirement for state employees, but not in the private sector. Nevertheless, it's probably something that we'll see, likely in the next 10 years, I would suspect. Keep in mind that also Philadelphia and Pittsburgh, as municipal ordinances, have required paid sick or family leave for employers operating within their respective city limits. Philadelphia also enacted an ordinance that's sort of interesting, requiring employers within the city, if any employer with 50 or more employees is required to offer an IRS qualified transportation fringe benefit plan. Basically, these are plans that allow for pre-tax deductions for mass transit expenses or for bicycle expenses. Obviously something, that's been enacted to try to ease the rush hour hazards of working in the city. But again, something that I wouldn't be surprised if we see on a national agenda at some point. The last one, this is really more geared towards those of you who are in the hospitality industry or perhaps in the transportation industry. But California and Virginia have passed laws designed to require private sector employers to get involved in combating human trafficking. So in a nutshell, not to spend much time, but if you are a covered hotel within those states, you have to post signs, that provide information for victims of human trafficking in terms of where they can seek help. But more importantly, requires training of employees to spot questionable activities and how to, what to do, where to report it, et cetera. Sort of an interesting issue that certainly has bipartisan support. So again, wouldn't be surprised if we see something nationally in the next 5 to 10 years on that. Next slide. So this slide here is a very broad topic, but it really, I just wanted to take a little bit of time to talk about the challenges of hiring in this day and age. There are 3 basic truths that we can sort of say when we're summarizing today's labor market. First of all, it's a very tight labor market. Many of you are hiring candidates, applicants who 10 years ago you may not have even given a second look at. We're seeing, employers are just having challenges finding adequate applicants. Secondly, clearly the regulation of the hiring process has never been more challenging for employers. There are more regulations and legal landmines to keep an eye on. And then the last truth is that applicants have never been more educated regarding their legal rights. So those 3 truths combined really spells for, I think, a tidal wave of litigation involving the hiring process. We're certainly seeing it in our practices. So just a few points under this general heading. And again, the point here is not to make you experts in any of these particular laws, but just to point out very quickly some of the landmines you can find yourself stepping on. Medical marijuana, we all know that Pennsylvania passed a medical marijuana law a number of years ago. And we still have some clients who feel that it's okay to say, we don't hire medical marijuana users. It is true that if an applicant is applying for a CDL truck driving position, any position regulated by the Department of Transportation's drug testing regulations would give you a basis to say we can't employ you as a truck driver. But with that one exception, and there are a few other minor exceptions, most of us cannot legally say we don't hire folks who have a card or who use medical marijuana. There are, as I said, there are some other exceptions, but unless we can demonstrate that the use poses a safety threat based on the safety sensitive nature of the position, having a blanket rule against hiring MMJ users is a real problem. So you need to take a look at that if that is your position within your company. Criminal history. Interestingly, in the tighter labor market, we're seeing more and more candidates, folks who, maybe try to keep a lower profile are now applying for very visible jobs. Just last week, and I'm not exaggerating, I had 3 separate clients call alarmed because they had received applicants from individuals who are registered sex offenders. The key law in Pennsylvania to keep an eye on here is called the Criminal History Information Act, which basically says you can't use someone's criminal history against them in the hiring process unless they've been convicted. So it can't just be an arrest, but a conviction. Conviction has to be for a felony or a misdemeanor, so summary offenses don't count. And then the real tricky one is the conviction has to affect the individual's suitability for the position. So, if I am a convicted tax fraudster, certainly that's going to affect my suitability if I'm applying to be a controller or an accountant or something along those lines, or an attorney. But what if I'm applying to be a third shift custodian, at a facility? My record of tax fraud probably doesn't affect my suitability to be a custodian. Well, then you have to extend that to, the tougher cases of sex offenders, registered sex offenders. Certainly, if you're applying to be a babysitter, daycare worker, dealing with, fragile or vulnerable populations, very clearly a basis for rejecting a candidate on that basis. But again, what if it's a position applying as a third shift custodian where they're really not around anyone, or any other position where they're not dealing with people in secluded environments, et cetera. So just an issue to be aware of. If that issue hasn't landed on your desk involving sensitive criminal history, it probably will at some point. English proficiency requirements. 10 years ago, many more companies than today used to say you have to be able to speak English in order to work here. Given the labor shortage, more and more clients are saying, you know what, being fluent in English isn't as important as we thought. We really need employees. And so they're dropping those requirements. There are some laws involving English proficiency. The one to keep in mind is that, generally speaking, if you have an English only rule, meaning you must speak English at all times within our facility, that's generally going to be a problem under EEO laws. At the very least, you should allow folks to speak their native tongue while on break or in break rooms. You may be able to require English in production areas, but even then, if there's not a bona fide, legitimate job-related reason for doing so or safety reason for doing so, that may be subject to challenge. Transgender applicants, gender identity is now a protected class under federal and state law, EEO laws. So discrimination against folks who are transgender is illegal. Likewise, gender dysphoria, which is the term for the condition that would lead some individuals to want to get surgery to change their gender or to affirm their gender, is also considered a disability which would require accommodations under the ADA, meaning perhaps leave of absence and any other reasonable support that may be required for that transition. Again, these are items that if you're closely following HR, you're well aware of this, but if HR is not primarily on your radar. This may have slipped by you. And it's important to be ready for these situations, because when those candidates land in your office for the interview, if you're not, up to speed on what your position needs to be, you can land in a lot of hot water. The last bullet point there, great applicant, love him, except his last job is listed as union organizer. We're seeing more of that, and Mike is going to talk a little bit about the surge in union activity. But this last bullet point refers to a phenomenon called salting, and it's something that unions do. They basically will have their organizers come and apply to work with your position, with your company. Oftentimes they're very well qualified, but they list union organizer, basically daring you not to hire them. Because if you choose not to hire them based on their prior union past, if they're the best qualified folks, that is a basis for an unfair labor practice charge, a lawsuit under the National Labor Relations Act, for which you could be held liable. So again, these are just some of the landmines to keep in mind. Be ready for them. Back to Micah.
Yeah, thanks, Eric. So the challenges with attracting and retaining talent don't end with the previous slide and the concepts that Eric talked about. Over the past 2 years, we have seen employers struggle to find qualified applicants and to keep the employees that they have. The buzzword that was assigned to this phenomenon and that we've heard thrown about over the past year and a half is the Great Resignation. Where are all the workers going? And so employers have turned to increasingly creative strategies to attract talent and to retain the talent that they do have. And many times we see employers implementing new financial incentives for applicants and for current employees to keep them on the job. And so some of the most common strategies, we just want to highlight some of those for you for your consideration. Maybe you're looking at ways to attract talent or to keep the folks you do have in this tight labor market. And so we often see employers first turning to new hire bonuses. So drive across the turnpike and you'll see on billboards advertisements for trucking companies. Hey, we're hiring 75 cents a mile and a $3,000 sign-on bonus. That's what we're talking about on a new hire bonus. It's something that an employee would be paid to sign up and start working. We also have clients that are paying retention bonuses for people that they want to keep. So you've been here for 5 years. We don't want to lose you. Here's an extra X amount of dollars to keep you here. Employee referral bonuses, turning to your employees to recruit new folks for you. Hey, mention something to your friends, mention something to your family, to the people that you associate with outside of work. Let them know that we're hiring, and if we do hire them, we'll pay you a bonus in that circumstance. Employers are also offering to pay increasingly for training and certification for employees. So if you come to us and you need a welding certificate to do this job, or you need a forklift operator certificate to do this job, don't worry about it. We'll pay for you to get that training. We'll pay for you to get those certifications, because we need bodies in the position, and we'll train you up and we'll get you the certifications that you need at no cost to you. Employers are also increasingly offering telework and flexible work hours. So those jobs that used to be 100% in office, through the pandemic, employers have sat down and sort of looked at that and said, maybe we don't need people to be in the office all the time. I know that was sort of one of the things that really made me nervous at the outset of the pandemic, when we had to sort of go home and we were a non-life sustaining business and we couldn't be in the office in person. I had never worked remotely before. And then, I wasn't sure how it was going to work out, but we see that so much of our jobs can be performed on a remote basis. And many employers are now offering that as a benefit. And frankly, many employees are expecting that. If I don't need to be in the office, I should be able to work from home. Employers are also offering unlimited paid time off, which, 5-10 years ago may have sounded like an absolute crazy idea to most HR folks. But again, now with with sort of this shift in the labor market, the tightening of the job market. Some employers are moving over to a model where if you get your job done, you get your work done, we don't care how much time you take off. As long as you're serving our clients or serving our customers and doing your work proficiently, you can have as much time as you're able to have for yourself. Student loan assistance is another big incentive that employers are starting to offer. I think we've all seen the headlines about the student debt crisis in the country, and employers are leveraging that to attract talent by saying, we will offer some level of reimbursement or some level of assistance to you in repaying your student loans. And then finally, cost of living adjustments and bonuses. Again, we hear about inflation all the time in headlines. And so employers are looking at that as a way, again, of sort of attracting talent and turning a negative into a positive by saying, hey, we adjust for that. We account for that. We take that into consideration and we offer cost of living increases. So when you use these strategies, they don't come without challenges. There are some issues that employers need to be aware of, both from a legal perspective and from a morale perspective. And the first one we want to talk to you about is, more of a morale issue. So if you are inclined to offer new hire bonuses, you're inclined to offer that increased pay to new hires, think about what that might mean for the folks that are already working for you. If you have an employee who's been with the company for 5 years and didn't get a bonus to sign on, and he knows that the worker hired to stand next to him and do the same job just got a $2,000 sign-on bonus, what might that mean for morale? And so, certainly take into consideration how offering those benefits to new hires may impact the folks that have been with you for a while, and you would consider potentially paying some type of a retention bonus or offering some type of a wage increase for your continuing employees to sort of offset some of that morale issue. So with respect to non-discretionary bonuses, some of the bonuses that we talked about on the previous slide would certainly fall under non-discretionary. We've got to take into consideration the payment of those bonuses for regular rate purposes when we're calculating overtime entitlements for our non-exempt employees. So what is a non-discretionary bonus? Well, generally that's going to be a bonus that's based on a predetermined formula that takes into account employee quality or accuracy of work, their attendance, safety records, employee recruitment efforts potentially, and we'll talk about that in a little bit more detail here in a minute. But those non-discretionary bonuses are going to need to be factored into the employee's regular rate when we're calculating overtime entitlement. There is one important exception to this rule, and that is the concept of a percentage of total earnings as a bonus. These bonuses are paid under a prior agreement under which an employee receives a bonus, and the bonus itself contains payment for overtime implications associated with that bonus. And if you're unsure whether any bonus that you're paying would qualify as a percentage of total earnings bonus, it probably doesn't. But if you're unsure how that would affect your employees' entitlement to overtime, again, it's certainly important to talk to either your accountant, your attorney, and make sure that we're making appropriate overtime considerations. So, our last point here on this slide is to make the important distinction between a one-time sign-on bonus and a bonus paid after completion of a period of training or a probationary period, something like that. So a one-time sign-on bonus is, thinking back to that example where I talked about the billboard, right? It's you sign up with us, we're going to pay you $2,000 just for becoming our employee. There's no precondition attached to it other than you become our employee. You become our employee, you get the bonus, and that's all you have to do. That bonus would not be factored into a non-exempt employee's regular rate for overtime purposes. But if we put a hook onto that bonus, we'll pay you the $2,000 sign-on bonus if you're with us for 90 days. Now that edges it over to a non-discretionary bonus, and we want to make sure that we're considering our overtime implications for that payment. Let's move on to the next slide. And as I mentioned, we wanted to talk a little bit more in depth about employee referral bonuses and some of the common issues and considerations that employers need to take into account when paying these bonuses or offering these bonuses to employees. So first, we want to have a clear definition about what is going to trigger a bonus payment for an employee referral. So you want to define, who's eligible to receive the bonus, what employees are able to participate in the plan, when that bonus vests in the employee. Is it if they get someone to apply to the job? Is it if their referral is hired? Is it if their referral is hired and remains employed with the employer for 90 days or some set period of time? All of that should be predetermined in advance and preferably put into a written policy so that if disputes would arise between the employee and the employer about whether a referral bonus is due, that we can point to clear policy language to support our interpretation and our position regarding the payment of that bonus. So compliance, again, with wage and hour laws for non-exempt employees with respect to an employee retention bonus. As I alluded to on the prior slide, there could be some overtime implications for an employee referral bonus if we do not meet the three criteria on the next bullet point, which are participation in the bonus referral program is voluntary, so it's not something that we're forcing employees to do. We're not mandating that they go out and recruit for us. It's purely voluntary that they engage in that recruitment activity. Secondly, employees' engagement in that recruitment activity is not a significant amount of time. So it's not something that we're telling employees to go out and do for 4 or 5 hours a night after they stop working. It's just sort of the casual conversation. Hey, just letting you know my employer's hiring. Those are the types of activities that are going to fall within this exemption. And then finally, recruitment activities are limited to, again, solicitation among friends, relatives, social acquaintances during employees' time not working. So again, I'm speaking to my friends outside of work. We're hanging out at the bar. Hey, my employer's hiring. If you're interested, let me know. Those types of solicitation activities would not fall within a mandatory overtime, or we wouldn't have to consider the employee referral bonus as part of a regular rate for overtime calculations if we meet those three criteria. If we don't meet those three criteria and we pay the employee referral bonus, then we will have to consider the overtime, or consider that bonus as part of the employee's regular rate for overtime payment if they're non-exempt. And then with respect to a couple more concepts we want to talk about with respect to retention and recruiting payments. So, we see employers use tuition repayment agreements. And, one of the things that we get, I think, calls on pretty regularly are, hey, I had an employee sign up for a tuition reimbursement program. They were required to remain with us for a certain amount of time. And they didn't meet that threshold, and now we want them to repay the bonus. Can we take a deduction from their final paycheck to repay that bonus or repay that tuition benefit that we offered them? Well, the Pennsylvania minimum wage or wage payment and collection law, contains very specific rules about what may be deducted from employee pay. And if we don't meet those specific rules, the deduction would be impermissible. So, you want to make sure that we have written agreements in place. We want to make sure that to the extent that we consider requiring payroll deductions to repay these loans and these assistance payments, that they fall squarely within the ambit of the minimum or the wage payment and collection law. Because if they don't, again, we'd be in violation of the law. So with respect to minimum employment retention period agreements, again, we're talking about, we'll pay you a bonus, and that bonus will vest if you remain employed with us for 2 years, and an employee quits a year and a half in. What does it look like if we involuntarily terminate an employee under one of those agreements? Does the employee have to pay us back the bonus? Does the employee get to keep the bonus if we involuntarily terminate? Again, this should be something that we have in writing, very clear, worked out prior to the payment of the bonus, so that if a dispute would arise about whether the bonus can be retained, that we have our writing to fall back on. And the last thing to consider is whether we're altering the at-will employment relationship. So in Pennsylvania, employment by default is at will. Either the employer or the employee can terminate at any time for any reason or no reason is law at all. By having a minimum employment period or a retention period agreement, are we altering the at-will nature of the employment relationship? And generally the answer to that can be no, but we need to make it very clear in the nature of that agreement that the answer is no ahead of time. Eric, I think we'll jump over to you. We've got about 15 minutes left, and we've got a bit of ground to cover.
Sure, no problem. So the next, if you could advance the slide, there we go. The next 6 slides actually deal with what I call a telework dilemma. This first slide just talks about how many companies have they're not entirely comfortable with teleworking for a variety of reasons. It could be concerns about productivity. Is the employee, actually gardening at home as opposed to working? But there are other issues, such as wage and hour compliance, tracking hours, safety issues, and just a variety of concerns. Next slide. These slides deal with the question of, can an employee ever have a right to telework? Certainly, many employees prefer to telework, and some employers, allow it either full time or on a part time basis. But under the law, can an employee ever have the right to telework? And this issue has been kind of knocking around the EEOC for a number of years. And if there is a right, it primarily comes under the ADA, the Americans with Disabilities Act. Back in 2003, the EEOC issued some guidance that said, in some circumstances, an employee may be entitled to telework as a matter of reasonable accommodation if getting to work or working in an office environment is not suitable given their medical condition. And of course, the issues there are going to be, what are the work restrictions, and can the employer offer accommodations within the office environment that can allow the employee to successfully perform the position? Or, can the employer establish that, hey, teleworking just doesn't work for our operation, so the employee is not going to be able to perform the essential functions of the position? For example, a supervisor who needs to be on site to supervise the direct reports, generally is not going to be, able to perform those duties remotely, at least in some circumstances. Next slide. So that was, sort of the position of the EEOC back in 2003. And, the traditional defenses that an employer raises are, teleworking creates an undue hardship or may prevent the employee from performing essential functions. Maybe it's not feasible from a technology perspective, or maybe there's an alternative accommodation other than teleworking that will allow the employee to, continue to work in the office. Next slide. So in 2021, December 13 of 2021, the EEOC sort of updated their guidance because again, by then we were largely, through much of the pandemic and the whole telework, what I call the telework revolution. They updated their guidance, and the question was, if an employer permitted telework to slow the spread of COVID, when an employer reopens the workplace and recalls employees, does an employer automatically have to grant telework as a reasonable accommodation? If many of these workers have been teleworking for 18 months now, 2 years now, do they have a right to continue that? The EEOC answered that question as no, but there were a lot of caveats. They say the employer is entitled to understand why the request is made. The employer may offer alternative accommodations, and employer does not need to eliminate essential functions. But the key language is that fourth bullet point, where they said that the fact that an employer temporarily excused performance of one or more essential functions when it closed the workplace does not mean that the employer permanently changes a job's essential functions. That telework is always a feasible accommodation, or that it does not pose an undue hardship. But at the end, it's clear, though, that they didn't really change their ultimate conclusion, which is if there are no other feasible alternatives, and if teleworking is medically necessary for the employee to perform their safety sensitive, to perform their essential job functions, and it doesn't cause an undue hardship to the employer, in that instance, it may be required under the ADA to allow teleworking. It's a lot of ifs, it's a lot of caveats, but it still can happen. So the questions, to consider if your business happens to be averse to teleworking, consider is in-person performance of the job essential to get the job done. Consider operational difficulties posed by remote work. Engage in an interactive process with the employee to understand, what's the basis for the need, whether there's alternatives, and a number of other things. So these are the defenses if you are inclined to reject a request to telework. Next slide. There's some don'ts to follow if you're engaged in that. Don't just have a blanket policy saying we never allow teleworking. Don't just assume that every medical condition is a disability requiring an accommodation, and don't hesitate to engage medical professionals in the process. They may have some ideas that will allow an employee to continue to report to an office environment. So there's a number of factors to consider when you're posed with a request to telework from a medical basis. Next slide. And with that, I'm going to turn it over to Micah to discuss the surge in union activity around the nation.
Yeah, that surge is something that we've seen certainly progress over the past year and a half. That surge is something that is sort of spreading beyond the bounds of what we would consider to be, traditional industries where union activity occurs. So we're not just talking about heavy manufacturing, trucking, shipping, those types of things. We're seeing massive organizing campaigns at places like Starbucks, Apple, Amazon. And so when you see that type of activity in those sort of non-traditional union sectors, it's noteworthy, and it's certainly something that's making news headlines around the country. And so it underscores the point that every employer should at least have a basic familiarity of what their rights are, what employees' rights are with respect to union organizing, and what to do in case union organizing activity is observed at an employer's particular place of business. So the first thing we want to talk about is what not to do. So the National Labor Relations Act makes it unlawful for an employer to engage in certain conduct toward employees who are participating in or expressing views on union organizing activities. So first thing we cannot do is we cannot threaten employees. If you vote for the union, you're going to be fired. Or if you try to bring a union in here, I'm going to transfer you to night shift. Those types of threats are 100% unlawful. 100% will get you hit with an unfair labor practice charge, and it's going to be a charge that will be very difficult to defend. You also can't intimidate employees to dissuade them from engaging in union-related activities. You also can't go the other way and try to bribe employees to refrain from union organizing activity. So, hey, if you vote against the union, I'll give you $1 an hour pay increase. That's also illegal. The final thing we can't do is we can't spy, we can't surveil employees to see if we can ascertain whether their union affiliation or proclivity with respect to unions sways one way or another. We can't question them and interrogate them about whether they favor or disfavor unions. We can't question or interrogate them about whether they are part of an organizing campaign or an organizing activity. And that extends beyond the walls of the workplace, right? So we can't drive down to the union hall and see whether any of our employees' cars are parked outside. We also can't do it virtually. We can't jump on Facebook and snoop through folks' pages to see if we can ascertain what their union position on labor unions might be. If we do those things, again, it will likely result in an unfair labor practice charge. But it doesn't mean that we don't have any rights ourselves as employers when employees do start to engage in union activity within a workplace. We're certainly entitled to express the company's view on labor unions. We're entitled to express our opinions and our experiences with respect to labor unions. We're entitled to educate employees about what union membership might involve, such as paying dues, potentially being exposed to fines and fees by the union if we don't follow the union's directives. So the important takeaway from this slide is, again, union activity is expanding. It's expanding into industries not traditionally associated with unions, and that if you do have union organizing activity afoot and you're not quite sure what to do, it's a great time to pick up the phone, call counsel, and make sure that we're not stepping out of bounds under the National Labor Relations Act. Move to the next slide, please. National Labor Relations Act applies to all employees, for the most part, all employees in the private sector. And it applies regardless of whether those employees have a labor union representing them or not. And there are certain rights that employees are conferred upon employees under Section 7 of the National Labor Relations Act. And those rights are generally called protected concerted activity. And those rights include the ability to discuss their wages with each other. A lot of employers prefer employees not to be able to talk about what their pay is, but the National Labor Relations Act says that's something that they're entitled to do. Employees are also entitled to come to the employer with complaints or concerns about their working conditions. So that could be better hours, better benefits. They're allowed to talk to the media and talk to the government about their working conditions. And so if employees are engaging in that protected concerted activity, it's important to understand that it is in fact protected under the National Labor Relations Act, and we shouldn't take action against employees for engaging in those activities that are laid out here on this slide. If you want to move to the next slide, please. Over the past handful of years, it seems, in addition to all of the chaos that has come about as a result of the pandemic, we've seen a massive shift as well in employees taking positions on issues that are pervasive and in the public. And some of those issues touch on things such as race relations, reproductive rights, abortion issues, issues that involve religious topics. And so employers are oftentimes challenged with the task of, how do we handle that when it happens here at work? Well, the first place that we want to look is, what do our policies say? Does the content of the speech itself violate any of our policies? So is an employee speaking respectfully about a race relation issue, or are they speaking in a way that could be considered bullying or threatening toward other employees? So we want to make sure that when we look at this topic in the workplace, that we are certainly applying our policies consistent to these topics, as well as those that we traditionally have to deal with. If you want to move to the next slide. There was recently a case issued by the National Labor Relations Board in which an employee defaced an overtime sheet. The employer had a sign-up sheet where employees were supposed to sign up for overtime. An employee who had sort of pro-union tendencies wrote, quote, "whore board" on the overtime sheet. That employee was terminated because the employer prohibited the use of profanity, at least under their policies, prohibited the use of profanity and graffiti in the workplace. National Labor Relations Board found that this employee had not or had engaged in protected activity under the National Labor Relations Act by writing poor board on the overtime sheet because the employer didn't consistently enforce its policies regarding profanity and regarding graffiti. There was evidence that came in throughout the case that other employees had written vulgarities on various sign-up sheets throughout, and those vulgarities were unrelated to union activity. And so what the National Labor Relations Board found was, because this employee's pro-union stance and pro-union position and basis for the graffiti was the determining factor in his discharge, the employer violated the National Labor Relations Act. So consistent policy enforcement is key to sort of dealing with these challenging issues that are emerging. With respect to union organizing activity, again, we want to make sure that our supervisors understand what is in bounds, what is out of bounds if we have an organizing campaign taking place at our workplace.
Just very quickly to close up the next slide, OSHA issued some guidance. Employees who complain about COVID or an employer's lack of attention to COVID protocol are protected under OSHA. They cannot be subject to discrimination or retaliation. So OSHA issued guidance in terms of what employer requirements are there. And then the next slide, actually the last three slides, just deal with the fact that long COVID, you know, the ongoing conditions or symptoms related to COVID is or may be a disability under the ADA, requiring accommodation and preventing discrimination or retaliation against someone who complains of having long COVID. It is 11 o'clock on the dot. Pleasure to be with you today. Thanks for your time. Feel free to email us any questions that you may have or direct them through Trout. Appreciate it.